So the first question is, well, what is the role of a construction attorney? And it's those things listed there. That's what construction attorneys do. And all of you have been involved probably in just about everything on that list in one form or another. But in federal government construction law, it's a little different. When we talk about the contract, you really don't negotiate a federal government contract. It's an adhesion contract. The government says, here it is. If you want the contract, sign right here. There are.
It's okay.
Now it seems to be working. It wasn't advancing.
I knew I was coming, so.
Probably, yeah. Let's just double check. Yeah, it's advancing.
Okay.
It just stalled for a minute. There are contract interpretation issues, but of course there are government contract clauses, and they're probably different than traditionally construction attorneys would see. And there aren't any liens on a government contract. You can't lien a federal job. There are bid protests, but they're a little different. We'll talk about those a little bit later. There are payment and performance bonds under the Miller Act. And of course, when you have litigation on a federal government contract, it's never a jury trial. It's either before an administrative board or a court. So there are those rather considerable differences over what you might see in general construction practice. What really makes it so different and separates it from everything else that most construction attorneys would be used to is the procurement process that's involved in federal government contracting. It's very different. You don't get a government contract unless you're first of all qualified to be a government contractor. The federal government doesn't want people to learn on the job. They don't like brokers. They like established government contractors, and there's a whole phase to what happens in the procurement process. There's some need created by the government, whether it's an act of Congress or it's ongoing money like disaster relief or hurricane or cleaning up the beaches or military construction on a base. There's some authorization for it, there's some funding for it, and the government then decides, okay, we've got this need, we've got this money, how are we going to procure it? So what I'm going to try to do in a very compressed period of time is sort of give you a federal construction contracting 101 to just let you know what some of the issues are. The process not only involves the things I just said, but you have to be registered as a government contractor. And the registration is in a place called the System for Award Management, affectionately called SAM.gov. And anyone who wants to bid or receive an award of a federal government contract has to be registered in that website. And again, you have to establish at some point that you have the capabilities to do a federal construction project. There are a lot of different agencies involved. In our federal construction practice that we do in our group, it's mostly the Army Corps of Engineers, to a somewhat lesser extent, the Navy Facilities Engineering Command called NAVFAC. NAVFAC is sort of the version of the Corps of Engineers in the Navy. But then you have the Air Force, and you have the Veterans Administration, you have the Department of Interior. So you do have some other agencies, but the largest group is the Army Corps of Engineers. A lot of our practice involves dredging. We represent more dredging contractors than any law firm in the country, and we're very heavily involved in dredging, and the Corps of Engineers is responsible for dredging the navigable waters of the United States. So we get into a lot of that, but we also get into military construction, and we get into military construction in a lot of places, including not only throughout the United States, but Afghanistan, Saudi Arabia. We just picked up a big case in Saudi Arabia, a few projects in Israel. So in some ways, we have an international government contract practice. When you're dealing with government agencies, it's good to know something about the hierarchy. You're always, as a contractor, dealing with a person called the contracting officer. And the contracting officer operates under a warrant of authority. Sometimes they have unlimited warrants of authority, which means they can award a contract for just about any amount of money on behalf of the United States government. And they're very careful about how they exercise that ability because they're binding the United States to pay for it. And contracting officers take their jobs very seriously. Some of them are very experienced. Some of them are not so experienced. Some of them are easier to deal with than others. There was a time when in the Army Corps of Engineers, all of the contracting officers were military personnel, many times colonels. I kind of like that because they seem to be people who wanted to work on an executive to executive level with a contractor, president to president level, and you could get things done. And for the most part, those contracting officers who were in the military only had a 3-year tour of duty. And if you're lucky enough to catch one of them when their tour was almost up, they would want to settle cases because they wouldn't want to leave them for the successor. So that was a good situation. Well, it came to pass that the military guys and women did not want to do that anymore because they're more interested in getting new projects and things that are a little bit more futuristic. And so they talked the powers to be, and let's take this contracting officer authority away and let's give it to civilians. Well, now you've got civilian contracting officers, some of them who are there for 30 years. That's fine if they're easy to deal with, but more times than not, we find that they're not so easy to deal with. That's kind of good for lawyers, but it's not always good for our clients. So you have to be somewhat familiar of the contracting officer, the subordinates to the contracting officer. The Office of Counsel is always involved, and that's, of course, who we have most of our contact with. When you're getting involved in federal contracting, the acronyms will absolutely drive you crazy. And I can tell you that if you're talking to a potential new client and you want to convince them that, yes, you can help them with this government contract case, be careful because while the contractors may not be very well schooled in the law and may not know how to draft bid protests or claims, they know the terminology. So if you sit down with a prospective client and he says, look, the CO just sent me this letter, I don't think you want to say what's the CO. You're given on something as fundamental as that, you've probably lost that client right away. But there's the administrative contracting officer, the ACO, the COR, the contracting officer's representative. One of the things we get a lot of questions about, I just bid a MATOC. What the heck is a MATOC? Well, it's a multiple award task order contract. I only know it because I've been doing it for so many years. But if you hadn't been, you would never know it. So you've got to know something about the lingo. As new clients, they're not so easy to bluff, and they'll figure out whether you know anything about the subject. Now, the administration of a federal contract, as I said, starts with a contracting officer and the people that are listed below the contracting officer. I'm showing a contracting officer wearing two hats there. The two hats are, on the one hand, the contracting officer is to protect the interests of the government and interpret the contract, but the contracting officer also has responsibility to be fair and impartial to the contractor. So when a dispute comes up, they're supposed to put on that other hat. Sometimes they do, and sometimes they don't. But I'd always marvel when I go to a meeting with one of my clients. Of course, now they're almost always virtual, but when they used to be in person and you'd have a room like this, it's a good idea to know who it is you're talking to on the government side. Sometimes the person who's the most vocal in a government meeting is certainly not very close to being a decision maker. That person is just someone that doesn't like your client or feels very strongly about what happened on the project and talks a lot. That person sitting on the corner who is very silent, that might be the person you need to convince. So if you don't know the positions of the people in the room and where they fit within the hierarchy, you're at a disadvantage. So it's a good idea to take a look at things like that. Now, there are many laws, and we could spend the whole day just talking about them. Many laws that govern federal government contracting. The Competition and Contracting Act is one of the major ones because it basically requires the government to promote full and open competition to be fair to everyone. The one as lawyers we get into the most is the Contract Disputes Act of 1978 because that's the law that establishes the disputes procedure. And if you have a claim or an appeal, where do you take it? You can get legal fees under the Equal Access to Justice Act. And the other things that are listed there also come into play, and at some point in time, you would need to be familiar with them. Now, I'm going to talk to you about the Federal Acquisition Regulation. That's called the FAR. One thing I got to caution you about, and so many people do it, they refer to it as the FARs with an S on it. And it makes a certain amount of sense. I mean, there are 53 volumes of regulations, plural, but it's referred to as the Federal Acquisition Regulation with 53 subparts. And the reason I mention that is when you're talking to anyone in the government, if you say, well, no, the FARs provide something different, they immediately going to register that this person doesn't know what they're talking about, or they wouldn't have referred to it as the FARs. And I still find myself doing that when I'm talking to consultants and people like that who use it that way. So I would just say, if you want to talk about the Federal Acquisition Regulation, call it the FAR. It's not an easy set of rules and regulations to learn. 53, I mean, when I started with the government many years ago, the FAR wasn't in existence. The regulation was called ASPR, the Armed Services Procurement Regulation. It was still 53 volumes. My first job, the chief counsel said, Mike, these are the regulations you're going to have to deal with. And I want you to spend the first week just sort of reading through it and seeing what it's all about. I'm telling you the truth. 53 3-inch, 3-ring binders. It was all in paper. I had no idea what I was looking at. I had no idea what was important. And it was a total waste of time. The way you get familiar with those regulations is you have a problem that involves one of them, and then you become familiar with that. I now know I better take a look at Part 14 because that's sealed bidding, and I better look at Part 15 because that's contracting by negotiation, and I better look at Part 49 because that's terminations, and I better look at Part 52 because that's where all the government contract clauses are. And there are a number of others that I'm pretty familiar with off the top of my head. There also are quite a few that I don't have the faintest idea what goes on in those parts of the FAR because I never run into them. So it's a complicated set of rules and regulations. And of course, you not only have the FAR, but then you have these agency supplemental regulations that come under it. Picture a pyramid with the FAR at the top. So if I'm dealing with the Army Corps of Engineers and I've got contract clauses, well, they're for the most part FAR clauses. And nothing in the contract can contradict or overrule the FAR clauses. But then there's the Defense Federal Acquisition Regulation Supplement called DFARS. Has the same basic numbering system as the FAR, except the prefixes are 252 dot whatever the FAR number is. Well, that tells you that this is a DFARS clause that touches on the same subject as the FAR clause. As a lawyer, you better look at it because it's not allowed to contradict the FAR, but is certainly allowed to supplement it. And attorneys get in trouble in meetings with the government. Well, FAR 14404 says this. Oh, yeah, but did you look at the DFARS? It says this. It can be an embarrassing experience. And you not only have the DFARS, you have the Army Federal Acquisition Regulation Supplement, which comes under the DFARS. You have the Uniform Contract Instruction, that's the Corps of Engineers internal regulation. You have to really at least take a glance at all of them. Most of the time, the FAR is the final word on it, but not always. Well, it used to be, in my early days, that if I wanted to find something in the FAR, I had to actually get those binders out and try to find something. It wasn't well indexed, and you really didn't always know what was there. Fortunately, in an electronic world, we can now search things electronically. And the FAR is not available, as far as I know, in paper anymore. It's all electronic. And in the site that's up there, the acquisition.gov is probably the best place to get the FAR. But there's now a new resource that I'm becoming more and more familiar with called Chat Generated Pre-trained Transformer. You see, you didn't think I knew what GPT stood for. And this is a form of artificial intelligence And ChatGPT, over the last 6 months, for those who subscribe to the upgraded service, which I had to do since I love technology and gadgets so much, gave you the ability to create your own chatbot. And what you could do is say to it, I want you to create a chatbot that points to, in my case, I said, point into acquisition.gov and be prepared to answer any questions that's in that entire regulation. It took about 5 minutes to set it up, and it's called FarChat, not because I named it FarChat. I went into FarChat just for fun, and I said, and then the question's up there, what are the requirements under the FAR to establish a right to recover under the differing site conditions clause? Instantaneously, it started spitting out what's up there and the stuff that's on the following couple of slides. It's right on. It's absolutely, I'm not telling anybody to start doing that instead of reading the rules and regulations, but it's a heck of a good starting point. And it was right on. So I'm becoming more and more enthralled with the prospects of artificial intelligence in the law. My colleague Ryan Boonster is jumping in with both feet, and so is Joe Sine and others on the Best Practices Committee, and I personally think that the firm should encourage it. Someone made a comment that I really thought made a lot of sense not too long ago. They said, AI is not about to replace lawyers, at least not anytime soon. But the lawyers who embrace AI are going to replace the lawyers who don't. And I think there's a lot of truth to that. So at any rate, I found that if you wanna look up something in the FAR and you don't want to go to acquisition.gov and look through all the indexes and everything, give ChatGPT a try. Say, is there a FAR clause that deals with bonding requirements on a federal contract? I think you'll get your answer pretty quickly. Okay. Now, the FAR organization itself, I said, is 53 subparts. There are the ones that I mentioned that are the most important. FAR Part 33 deals with disputes, for example. FAR Part 36 deals with construction, 14 and 15 that I mentioned earlier. Those are the ones that you would look at the most if you're looking at the FAR. FAR 2.101 is a good place to look. It's a section of the FAR that provides definitions. And many times when you're facing a new term, like MATOC or one of the acronyms, I'll look it up in the definition section of the FAR because it'll be a really good starting point. And it'll point to other parts of the FAR that will give you more information. So I would highly recommend looking at things like that. And as I said, it's a little dangerous not to look at these other regulations. I don't know that anyone is as familiar with those as they are with the FAR itself, but you have to really be aware of the fact that they exist and that they're part of the regulatory system. Okay, how does the government buy things? Well, it used to be that almost all federal construction contracts were done by sealed bidding. And the award were made to the lowest responsive and responsible bidder. Responsive simply meant that you have responded to everything that's required in the solicitation. I had a job, my first job as an attorney. It was at a place called the Frankfurt Arsenal that did a lot of research and development contracting. I was told to start looking at bid packages that were coming in to determine whether they were responsive. And the way that often they were not responsive is these companies that were trying to furnish the government some product, some military widget of some kind, would decide to tout their own wonderful way of doing things by attaching to their bid something called descriptive literature. And I would look at the descriptive literature, and many times the descriptive literature that advertised the product that they were offering in response to the bid contained some criteria or specifications that were different from what was required by the solicitation. this product has to be able to withstand temperatures of down to 20 degrees Fahrenheit. They would say, well, this product is good for temperatures down to 32 degrees Fahrenheit. You wanna know what happened when they did that? They were rejected as non-responsive. And the rules of responsiveness are you can't cure responsiveness after bid opening because that would give you 2 bites of the apple. So the government throws the bid out for simple things like that. Responsibility, on the other hand, that's whether or not you have the capability to perform the job. So if you're the low bidder and you're responsive, but you haven't demonstrated responsibility yet, you have any time up to the time of award. And the government will conduct a pre-award survey and they'll say, well, wait a minute. You seem to be qualified to do this project, but it requires a very large tower crane. And we don't see anything that indicates that you have that type of equipment. Answer, well, I don't, but here's a lease agreement I have with an equipment rental company to supply the very type of tower crane that this project requires. You've now cured that and you're now responsible. I've seen contractors that weren't able to show that they had enough money to fund a government contract. And the contractor will say, yeah, but I have $1 million line of credit with PNC Bank. And here's the proof of it. So you can cure responsibility. But over time, the military became convinced that making awards to the low bidder wasn't always the best way to do things. Because you many times don't really end up with the best contractor. And you know, the analogy that was given, if you're hiring somebody to paint your house and the first person shows up 2 hours late to give you an estimate, has no references, it gives you a very good price. And the second person is right on time with a beautiful truck and gives you the name of 4 people in your neighborhood who he's done painting for, but his price is 20% higher. Who are you going to award it to? Probably the guy that's more expensive because you feel more comfortable. So the military said, we want to do business that way too. So we're going to start using contracting by negotiation, negotiated contracts. And the difference is, and I'll talk about it more in a minute, is it gives the government the flexibility not to award to the lowest price, but to look at some other things. Then you have other different types of contracts. IDIQ has become very big. Indefinite delivery, indefinite quantity. When I was at the Frankfurt Arsenal, we used to purchase ammunition with an IDIQ contract. We need 1 million rounds of shells over the next 3 years, but we're not guaranteeing we're going to order 1 million. Give us a unit price per shell, and we're going to tell you in advance we need 100,000 next month. The month after that, we don't need any. The next month, we need 150,000. You will supply them to us on an indefinite quantity and indefinite delivery basis. Well, that works for ammunition. How does that work for construction?
They have
It
to
does.
hold that price indefinitely?
Yes, on a unit price like that, of course, in this day and age, when you've got price escalation, and you probably could get the government to put a price escalation clause in. But how does it work with construction? They started doing it with construction. They called it a MATOC, a multiple award task order contract. The idea was, we're going to put out a solicitation to procure roofing replacements at all of the military bases in these 5 states. And here's a sample one. Give us your price for doing that one if it was awarded to you. And also tell us all these other qualifications that you have. And then we're going to select 5 contractors to be in this pool of qualified MATOC contractors. And what happens next is whenever any of these military installations need to have some roofing work done, the competition is only going to be among the 5 of you. Nobody else can submit a proposal on it. It's great if you're in that closed shop. It's not so great if you're not in the closed shop. Well, when this first started to happen, contractors were just going nuts because they said, we've got big contractors coming in from halfway across the country that are going to end up hiring me to do the job anyway, and I can't compete with them in bidding this big MATOC proposal. So I filed a fairly well-known protest at the time, and protesting the government's ability to award MATOC contracts for construction. And we won. We won the protest and it was shut down. I kept the Corps of Engineers from doing this for almost 2 years. I was one of the most hated people in the country and probably still am. But it was appealed to the Court of Appeals for the Federal Circuit. And after the case was argued, the court said, well, we understand, but we don't think the courts should be telling government agencies how they should procure the things that they need. We're going to trust them to do things that are in the government's best interest. So we're going to overrule what was done by the lower court. And then Maytalk was alive. Well, Maytalk's really alive now. The other thing that's listed there is SATOC, a single award task order contract. Well, that's a sole source. That has come to be pretty much frowned upon. All right, I explained sealed bidding to you. The common issues in sealed bidding are, if you make an error or omission in your bid, that may come back to haunt you later. So you got to be careful not to do that. Some contractors used to say, well, I know that this specification is not correct, but I'll get a big change order. And when I bring it to their attention after I get the contract, so I'll make some money on that. The only problem is if the government could show that it was an obvious error, omission in specifications, the law says you can't recover for it. You bought it. And the only way that you might be able to recover for it is if you showed that it's a latent error or omission that you had no way of noticing when you bid the job. And if it's ambiguous, then the ambiguity is construed against the drafter of the contract. Had a lot of cases over the years in sealed bidding with a mistake in bid. In most public contracting and certainly in private contracting, you're not going to get very far saying you made a mistake in your bid. Government's pretty fair about it. Government looks at it 2 ways. If you can show through clear and convincing evidence that you made a mistake, hey, I left out of my bid, here's my bid package, the requirement to put in this special type of equipment in this building. I just left it out, and that's why my bid's so low. I made a mistake, I'd like to withdraw my bid. Government will generally permit you to withdraw. The second step gets a little touchier. Well, I made a mistake, but I can show you what the mistake was, and I can show you what my bid would have been had I not made the mistake, so I would like you to allow me to have upward correction of my bid. And the rules are that you can correct upward if you can demonstrate those things, provided that you still remain the low bidder, obviously. And it's a tougher sell, but it can be done. I'll never forget, many years ago, had a contractor who was doing work for the Baltimore District of the Corps of Engineers. And he came to me, the guy was so upset. He said, Mike, I made a really bad mistake on this bid. And my bonding company told me, they're not going to stand behind me on this. I completely blew it. So I asked him to explain what had happened, and he had a pretty good example of what I was talking about. He missed actually a couple sections of the specs. So we you have to put together an affidavit, you have to explain to the Corps of Engineers what was done and request withdrawal. And of course, one of the things I said was, this contractor's been doing work for the government for 6 or 7 years and never happened to him before. They allowed us to withdraw, no problem. The problem came up when he came to me a month later. Same guy, he says, Mike, I made another mistake. I said, what, you never made a mistake in 6 or 7 years and now they're coming once a month? He said, yeah, but he said, I just don't know what to do. He says, once again, the bonding company has told me that, and this is a fairly big, $4 million job, that they're not going to stand behind me in this project. And that means I'm going to be in all kinds of trouble with the government. Can you do your magic again and see if you can get me out of this? Well, I put together the papers again. And this time we had a meeting in the offices of the Baltimore District, and the contracting officer there, it was a room like this with all these people. And I don't remember all the gory details anymore, but I know I gave them the best pitch that I could get as to why he should be permitted to withdraw. I was real tears and everything else. All of a sudden there's a knock on the door, and the door opens and someone says, Mr. Payne, can we speak to you for a minute? Well, what are you talking about? I'm making my plea here. I'm crying. Don't interrupt me. No, they called me out in the hall. And there was a gentleman I didn't recognize, but 2 other people who I later learned were from headquarters in Washington. he said, Mike, exactly what are you doing? I said, I'm trying to get withdrawal of this bid. And he said, no, we want you to ask for upward correction. I started pinching myself. So what do you mean upward correction? There's no basis for upward correction. We can't show what the bid would have been. They said, come up with something. The general needs to have this project done. Your client is the only game in town to get it done on time. Just come up with something to justify, even though it doesn't make a lot of sense, with something to justify upward correction. The skids have been greased. Higher authority is going to approve it. And that's the way this thing is going to go. So by this time, my client was very frantic, a nervous wreck, probably thought that these guys were coming to arrest all of us. And I asked for a timeout, and I called my client into another room, and I began to explain to him what had happened. And well, he grasped it pretty quickly. He says, Mike, this is terrific. We've got them over a barrel. He said, tell them I need more money. He said, I can't do it for $4 million. You know, I made a mistake. I'm going to need $6 million to do this project. Guy's name was Dave. I said, Dave, let me explain something to you. I don't think they're going to be receptive to that. What they did tell me, and I left out, was if he needs more money, if there are claims during the project, they'll probably be looked upon somewhat favorably. This kind of thing never happens, but it happened. So I convinced my client, no, we'll do what they said. We'll make, you know, without lying, we'll make some sort of case for upward correction. We'll submit it. Well, actually, my faith in the system got restored because that type of upward correction has to be approved by senior headquarters at the Army Corps of Engineers and the Office of Counsel, and they rejected it. So he didn't get the award under those circumstances. So what did they do? They went out with an emergency procurement, allowing all the previous bidders to bid on that emergency procurement. My guy got to submit another bid at a higher price, and he got the award. So who said the crime doesn't pay? You know, maybe it does.
Tax dollars.
Tax
whatever.
dollars.
Just tax dollars, right. Now, the FAR 16 tells you about all the types of contracts that there are. Most of them in construction by far are firm fixed price. You give the government, I'll do this project for $8 million, and that's what it is. There might be some line items and unit prices that make up that $8 million. Cost reimbursable contracts, while they're fairly common in lots of types of government contracts, like supply contracting, and certainly in research and development, they're not common at all in construction. They want you to put in a firm fixed price. The IDIQ contracts we talked about are very big nowadays. And of course, there are all kinds of small business set-asides. You know, you have historically underutilized business zones, hub zones, they get a preference. You have small disadvantaged 8A contractors. You have service disabled veteran-owned small businesses, and you have women-owned small businesses. And these types of small businesses and get preferences, and sometimes are the only ones who are allowed to bid on a project. So you've got to know what type of contract you're looking at when you get into this. Now, the contracting by negotiation, you know, you see that word negotiation. You know, most people think of negotiations as give and take. You know, I'm a business person. I'm going to sit down from you, and we're going to have a give and take. And we're going to compromise. We're going to negotiate this. That's not what this is. It's called contracting by negotiation, but it's kind of one-sided. Instead of submitting a bid, you submit a proposal to the government. Sealed bids are open on a bid opening date, and they're publicly opened, and everybody knows what everybody else bid. Not so with requests for proposals. It's kept secret. And it's evaluated by a source selection board, and they're looking for who's giving us the best value according to certain evaluation factors. And price is always part of it, but price is often not the most important part of it. The source selection team is going to be looking at a lot of different things. For example, these are the kinds of evaluation factors that they look at. They will look at things that represent key importance on the project. and that will allow them to make meaningful comparisons between one bidder and another. What are some of the factors? Oops. Well, they'll look at, they'll rate each offeror on this basis. You know, what's your organization like? What's your technical solution to this problem? I tell contractors all the time, the government has a problem here. That's why they come out with this. Show me you know how to solve it. What's your schedule? You know, if they want the project done in 365 days, tell them you'll finish it in 350 days. They'll like that. Don't tell them 380 days. They probably won't like that. What technical experience do you have? What are the qualifications of your personnel? This is where contractors often drop the ball. Sometimes a proposal is supposed to include resumes of your key personnel. Nobody likes to update a resume, so they don't. And then the resume of the person they're proposing to be the project superintendent shows he has a lot of construction experience, just never any on a project like this. And what's even more tragic is sometimes they do have that experience, but they just didn't update their resume. Well, they're not going to come out as well in an evaluation with others who gave the government better information about the personnel they're going to put on the project. And then, of course, past performance. Not a good idea to show that you've been losing money on every job and you've been terminated for default on most of them. That's probably not going to endear you. You want to show that you've done similar work in size and scope, that you completed it successfully, that you got good past performance ratings, and the government evaluates all these things. And then, of course, if you're a large business contractor, they look at your small business subcontracting plan because they want you to award some part of this big government contract to small businesses. And then last, as I said, but not least, price. What about price? Well, the solicitation will tell you many times that the evaluation factors collectively will amount to 50% of the evaluation. And that means 50% is price. Other times they'll say the price factor is going to be counted as significantly less than the technical evaluation factors. Well, that's when you've got a pretty good idea. If I impress them with my qualifications, even though I may not be the lowest price, I may get the award anyway. Of course, in the early days, probably 15 years ago, when the government began to shift from sealed bidding and construction to negotiated procurements, every contractor wanted to file a protest. What are you talking about? I bid $3 million and he bid $4 million and they're going to give the project to him. I'm the low bidder. She said, well, you're not really the low bidder. You're not the best evaluated offeror on a proposal. And they have a right to do a trade-off of price versus technical factors. Well, this is ridiculous. I want to protest it. Well, protest after protest, the GAO or the Court of Federal Claims would come back and say, we're not going to second guess the discretion of the agency of what's important to them unless you can show me some really gross negligence or fraud or something really terrible here. We're going to leave it up to the agency. So those types of protests quickly began to fall by the wayside. But even to this day, construction contractors are very unhappy if they had the lowest price and they didn't get the award. And if it looks like it's because they weren't given a high enough evaluation on the technical factors, there may be a basis for a protest. And we'll file protests like that. Sometimes you win, sometimes you lose, but we certainly get into it. Once the government receives proposals, they can make an award on the basis of initial proposals, and many times they do. Other times they'll open discussions. And that means is they'll send letters usually out to the contractors and say, well, we're concerned about this, this, and this. Give us some more information. Clarify this. And once that's done, you know, they'll establish what's called a competitive range. If there were 10 offerors on this project, they might send letters out. Well, you're one of the 5 who are in the competitive range. We're going to have these discussions with you. The other 5, thank you very much for your interest in this project. We wish you better luck the next time. Those people don't like being kicked out. Sometimes they'll file a protest and say, we should have been in the competitive range. Every once in a while, I find a protest like that until I discovered that, we usually win. They say, okay, you're in the competitive range. Never got the award ever. So that's kind of a waste of time. But if you're in the competitive range, that means that they're going to have discussions with you. Notice the government in the FAR doesn't call it negotiations. They don't negotiate with you, they discuss it with you, and they'll speak either in person or sometimes by letter only with each contractor and say, the type of roof you're planning to put on this building you're building, we have questions about that. Do you know that the spec requires this, this, and this? You might want to take another look at that. Or your price on this item, it seems to be out of line with what we think should be offered here. You might want to take a look at that. And you can go through a whole host of things, because at the end of that discussion process, you are given the opportunity to make a final proposal revision. And you can, in other words, reprice it and give more technical information to try to convince them that despite putting you in the competitive range, they not only should do that, they should award the contract to you. And then the source selection board sits down and they look at all these proposals and they make a determination as to who should get the award. I'll never forget one of the, I think it might have been George's client, wanted me to do an in-house presentation for them on government contracting. And one of the questions they said was, we've bid 5 or 6 projects and we keep losing on these negotiated procurements. Would you take a look at one of, like the most recent one of our proposals, and maybe take it back to your office and see if you can give us some pointers about what we're doing wrong? They said it has nothing to do with price. They're not liking our technical evaluation, even though we know we're qualified to do this work. I said, sure. So we took a break and I actually left the proposal on the table. I started looking at it. Took about a minute and a half. I said, well, I know why you didn't get this one. He said, why? Because they asked you for the qualifications of your project superintendent and you wrote to be determined. I said, they can't tell whether that person's qualified. Well, we haven't hired him yet. Well, I said, you should be talking to somebody you're planning to hire and put their qualifications in, because the government wants to know, for their own probably correct purposes, that you've got qualified people on this important job, and to be determined will lose it for you every single time. So things like that happen. Once the award is made, then the government has a few days to notify you. And of course, the awardee gets the good news that he's been awarded the contract. The others are told, well, there were 5 proposals and here's who got the job. And they'll give you some information about how you compared to the others. Not a lot, but some. And that's where the protest business really heats up. And that's when I call Casey McKinnon in Washington. He's become our protest guy, although all the other lawyers in our group do them as well. And you're sort of fighting in the dark, because you weren't selected. You know that your price may have been lower than the awardee, but you don't get to see how the others were evaluated. And the client will say, Mike, there's no way. They gave us a B rating on past performance. We always get an A. They gave us a C on quality of management. We always get an A. Of course, I'll say, well, probably the awardee had higher ratings in those categories. We don't know how. We want to protest. Well, what the tragedy of the system is, in order to find out if you really have a solid basis for protest, you have to file the protest, because that's the only way you can get the information from the government's records as to what their justification was. And you get it under a protective order. You're not allowed to give it to your client. You can tell them a little bit about what you found, but only the lawyers can look at it. So what happens is, once we get that information, we will say to our client, man, they dotted all the I's and crossed all the T's. This justification is pretty ironclad. I think you should drop it. And sometimes they'll listen to us and drop it. Other times we'll say, wait a minute, and you're onto something here. They didn't even look at this factor. They didn't document this. Their reasoning makes no sense. And then we'll proceed with the protest. So that's all part of this process. The thing that happens, though, is that there must be in a negotiated procurement, a post-award debriefing. So if you have a client who's lost out on a negotiated procurement, an RFP, they must request a debriefing if they want to file a protest with the Government Accountability Office, because that's an initial requirement. And the government plays it pretty close to the vest, because they know if they give away too much, they're just feeding the fuel for a protest. Sometimes my clients would ask me, do I want to be on the debriefing call? And I'll say, well, I'll be happy to, but that's going to have a chilling effect, because they'll know why I'm on. But the debriefing is what takes place. Now, this I always found was an interesting little chart that the Corps of Engineers put together. Why did I lose? Well, this is probably what these things that are listed here are probably why you lost, or among them. You haven't really shown us that you can solve our problem. And I also tell clients all the time, if you don't write well, get somebody who does. A lot of typographical errors or spelling mistakes or grammatical mistakes don't portray the best foot forward of your company. So hire somebody that can do some technical writing for you, at least make it look good, package it right. It's like when you were in grade school, the kid that handed a book report with a nice cover on it very often got a better grade. Package it pretty nicely. It's not going to sway the day, but it'll create a better impression. If you're dissatisfied, and as I said, they do, these are the places we go. It's always called the GAO. It's now called the Government Accountability Office. It used to be called the General Accounting Office. Interesting, they kept the same acronym, but just changed the terms. But that's where most of the protests go. You can protest to the agency itself. Many times they're not going to change their minds. The Government Accountability Office is where most of them go, or you can go to the United States Court of Federal Claims. And we've had some contractors that really are upset about what happened. They'll start with the agency and lose, and then they'll take it to the Government Accountability Office and they'll lose, and then they'll take it to the Court of Federal Claims. What a great day that is for us as lawyers. But it's not always a wise strategy, because if you've lost, especially at the GAO, chances are pretty good that the Court of Federal Claims is.
How fast is the turnaround on all this? I mean, do they award the bid and is this like clipping along every 2 weeks or like?
Yeah, Kathleen's asking how fast is the process here? In a Government Accountability Office protest, where most of them go, by statute they must issue their decision within 100 days, and they never missed it. And what they do is they go to the agency and require the agency within 30 days to provide an agency report of all the relevant documents. And then the protester can comment on that. And then they deliberate on it. And usually, in almost every case, the procurement is held up until that's resolved. If you go to the Court of Federal Claims, it can take a little longer, because they do it, they have the parties file cross motions for summary judgment. And you have an argument in court. And sometimes I've seen cases where the government convinces the court, Your Honor, this is an urgent procurement. And the court will set up an expedited schedule where it gets resolved in 2 weeks. Other times it's 4 or 5 months. So it's, depending on your perspective, the government hates it because it's holding up their job. And then, of course, the other portion of all this, and those are the bid protest procedures. Dispute resolution, we could have a whole CLE on this. Again, it's governed by the Contract Disputes Act of 1978. Unfortunately, I was in the government when it came through. What an unhappy day that was for contractors, because it made statutory that you couldn't put negotiating room in your bids anymore and your proposals anymore for on claims. Contractors say, well, I need $100,000 in this, but I'll ask for 200 and we'll settle for 100 and I'll be happy. The government started to say, we call that fraud. So under the Contract Disputes Act, you better be able to justify what you're asking for. I'll never forget the guy who came in to negotiate a claim with me when I was in the government, and he wanted $1 million. And we thought the claim was worthless, and we told him we denied his claim. But he brought a lawyer in, and they made a little pitch to us, so we weren't impressed. The lawyer said, Mr. Penn, can I talk to you out in the hall? I said, sure. He said, look, I can get my guy to take $500,000. We can settle this here today. I said, no. I said, we don't think there's any merit to the claim. So $500,000 is not going to settle it. He said, let me talk to my client. Comes back and will you give us $100,000? Now, this was after the Contract Disputes Act had been enacted. And that was a pretty good tip-off that he didn't think he had a solid $1 million claim. So the nice guy that I was, I referred it to the Justice Department for a fraud prosecution. He's probably still trying to find me to kill me. But, you know, you have to have a clause in the contract that gives you the right to request additional money. I've listed the main ones there. Probably most of ours are for defective specs under the changes clause or differing site conditions. Those are real big ones. And the differing site conditions cases usually end up in litigation because the government doesn't want to admit that they misdescribed the subsurface materials. And they're geotechnical people, they'll fight to the death, that no, the contractor doesn't get it. I had a case one time where my client ran into fractured rock that was supposed to not be fractured. This was a China Lake Naval Weapons Station. We went to trial. They actually had testimony from an expert that your client should have been able to tell from observation that this rock was fractured. I said, what observation? They said, well, here are satellite images that show the fractured nature of the entire site. I said, were those satellite images that you're showing us part of this solicitation package? Oh no, they were classified. We just got them released for the trial. And I said, is the interpretation of those classified images something that a construction contractor could do on his own? Oh no, you have to have an expert to know what this says. We won that case.
Yeah.
So that's what goes through in the dispute resolution process. Where do you file an appeal? Well, you know, you file a claim with a contracting officer. If they settle it with you, so much the better. Otherwise, you get a contracting officer's final decision. You can take it to a board of contract appeals, which is the Armed Services Board or the Civilian Board for the most part, the Court of Federal Claims. If you lose before the board or the court, you can go to the Court of Appeals for the Federal Circuit. Tough place to win. If you lose at the Court of Appeals for the Federal Circuit, the next step is the Supreme Court of the United States. Good luck. They're probably not going to grant you a certiorari. And, you know, again, those are the important clauses, and you get the slide presentation so you can take a look at those, and those are the FAR references. And, you know, a claim has to be certified if it's over $100,000. Contracting officer has 60 days to issue a decision. You've got certainly appeal periods. You can appeal to a board within 90 days. You can go to the Court of Federal Claims within 12 months. This contractor I mentioned in Saudi Arabia, he got in touch with us on what's going to be probably a $10 or $15 million claim 3 weeks before the 12 months are up. And he hasn't submitted the claim. We have to get the claims together and a complaint together all in 3 weeks. It can be done. But boy, it's not going to be too easy. I asked for a $75,000 retainer on that one. I learned my lesson. Okay, you now are all experts in federal government contracting, and I will feel free to ask any of you to help me when Ryan refuses. Thank you.
Thank you.
Thank you, Michael.
The CLE code today is 3803. Again, 3803.
This is IQ contract for a specific building.
Well, that's why they don't make it specific. Make it general. Say we're gonna do, so let's say that building is gonna house your new servers. They say we're gonna do an IDIQ for server buildings.
It was an existing building for the naval coppers. It was a total fucking. I didn't understand how they.
Was it a restoration or like maintenance type thing? Because they do it that way too. We're doing an IDIQ for restoration and maintenance services.
Sorry?
Just-
One person